Hello, my name is Deana Fleming, and I'm Associate Counsel for Guardian Ad Litem, and I'm here with you today to give you a legislative update from this past 2015 legislative session that impacts Guardian Ad Litem practice. There have been several changes to the juvenile code that you're going to encounter as you continue to work your case. So we have legislation I want to talk about is what's called the Foster Care Family Act. This is Section Law 2015-135, also referred to as Senate Bill 423. And first of all, these amendments comply with the federal legislation. The federal legislation is the Preventing Sex Trafficking and Strengthening Families Act of 2014. The way federal law impacts state juvenile law is draw down federal funds for foster care. And in order to continue to draw down federal funding, state, including North Carolina, needs to comply with certain provisions of federal law. So part of the things that the feds were looking at deal with normalcy for foster youth, and I'll talk about it in more detail, and also some things related to sex trafficking, recognizing that that's an issue with children that are involved in the child welfare system. So to normalcy for foster youth, what we're really talking about is that ability to grow up like a normal teenager. What we hear from many foster youth is that there's a stigma by being a foster child, that they had to receive permission of an agency in order to, for instance, spend the night at a friend's house. And ultimately, they ended up not doing these things because they would have to ask for a criminal record check. And it's hard enough being in foster care, but to have to ask a state agency for permission on how to do daily things in your life is certainly a barrier. So we want foster kids, foster youth to feel more normal in foster care. The other thing we're going to be talking about in some detail is called the Reasonable and Prudent Parenting Standard. This is also related to normalcy for foster youth and federal law. And then finally, we've reduced some driving barriers for foster children. What we hear from foster children is they never got life. And, you know, they age out of foster care at 18, and at that they can apply for their driver's license, but they haven't had any experience. So we want to make sure that that's not going to be a barrier for youth aging out of the system. So with to the Reasonable and Prudent Parent Standard, this is effective October 1st of 2015. It makes some amendments to Chapter 131D, which is foster care, and also changes to Chapter 7B, which is the juvenile code. And provides is that foster parents or an official in a group home are authorized to provide or withhold permission for normal childhood activities as long as they're using the Reasonable and Prudent Parent Standard. And this includes but not limited to extracurricular activities, intimate activities, and social activities for periods up to 72 hours. So this is what the Reasonable and Prudent Parent Standard provides in statute. It's authorized by careful and sensible parental decisions that are reasonably intended to maintain the health, safety, and best interest of the child, while at the same time encouraging the emotional and developmental growth of the child that a caretaker shall use when determining whether to allow a child in foster care under the responsibility of the state to participate in extracurricular, intimate, cultural, and social activities. So questions that has been raised is whether the Reasonable and Prudent Parent Standard, this ability to, basically act as a parent when determining whether foster youth should or should not participate in a time-limited activity, whether it only applies to licensed foster parents or whether or not it can also be a placement provider such as a relative who is not licensed. So initially, if you look at Chapter 131D, it's talking about licensed foster parents. However, because there's reference in the juvenile code under 7B903.1b, it appears that this reasonable prudent parenting standard is extended to placement providers. And this is to provide or withhold permission. So, it's basically using your best judgment as a foster parent and also considering the child or youth who's asking to do something. So every child is different. They're going to have different issues. Some children have mental health issues or developmental issues. That's all going to be coming into play when a foster parent or placement provider is using the reasonable and prudent parenting standard to give or withhold permission to the foster youth in their care. Now, what is provided in 7B903.1, our juvenile code, is that if authorization is not in the juvenile's best interest, the court shall alternative parameters for approving normal childhood activities. So there is some level of juvenile court involvement when it comes to the use of the reasonable and prudent parenting standard. So we have here reasonable. So let's talk about what potentially is reasonable. So hopefully you've got a couple handouts. One is applying the reasonable and prudent parent standard, and this is a list of 20 questions. And this is a guide that was developed by the Division of Social Services for foster parents to be able to use in applying the reasonable and prudent parenting standard. And I'm not going to go through all 20 of these, but you can see some of the questions that would certainly apply. Reasonable and age appropriate. Is it going to interfere with a visitation? Would own child to participate in this activity? So this is just a list of guidelines to help foster parents decide whether or not to let a foster youth participate in a particular activity. Out that you have is the activities guide. And so this is a 9-page guide, again, that was developed by the Department of Social Services at the division, so state level, to give some guidelines with respect to what would be approved and where a foster parent would need to seek permission from the agency. So we've got different categories. For instance, number one is family recreation, and this includes, camping, hiking, some sports activities. Really, any of these activities are fine as long as they don't last over 72 hours. But one area you're going to continue to see to be an issue with respect to permission, anytime there's target practice using a gun or bow, and whether that's, hunting or, practice, that is going to be something where the foster parent or placement provider really should seek the input from the agency. It depends on the child. It may depend on the area of the state. There's all kinds of factors. Water activities, as long as you're complying with the legal things, that's certainly permitted. 3, we have hunting, and again, that's something that you would need permission from the agency. Social and extracurricular activities, this can include field trips, youth trips like scouting, going to sports activities, spending the night away from a caregiver's home. And that's something we really hear from foster youth, former foster youth, that was certainly an issue in growing up in the foster care system. We've got motorized activities, and there's compliance with the law, but this is going to allow foster youth to be able to participate in activities with their foster parents that involve motorized equipment. And then some other areas, just to jump forward, let's jump to number 11, which is the child's appearance, and number 9, religious participation. So whether to attend or not attend a religious service of the child's choice, that's permissible, unless we know that there is an issue with respect to the biological parent or the religion is in conflict. In that case, you need to defer to the agency. And with respect to the child's appearance, you know, if there's some sort of medical treatment needed for life, then that would be something the foster parent can do. But if the child, if there's any kind of conflict with respect to the child's appearance between the foster parents and the biological parents, then that needs to be something that's going to go through the agency and potentially even to the court if it rises really to that level. With respect to cell phones, you know, that's something that's going to depend on the child. So this is just a good guideline. It's not going to cover everything. And it's always going to depend on really the child, him or herself, because, you know, age, background, you know, mental health issues, whether they do have good judgment or not judgment, if they're trustworthy, you know, all things come into play when a placement provider or foster parent is utilizing the reasonable and prudent parenting standards. But remember, the rationale behind it is to promote normalcy for foster youth. So this area that we want to talk about is foster youth, juveniles that are 14 and over. And as of October 1st, we have a new statute. It's 7B-912, and it requires the court to make specific findings about what services that DSS has provided for the foster youth to transition to adulthood, the reasonable and prudent parenting standard, and then age or developmentally appropriate activities. So we're just focused on really, you know, are these teenagers allowed to be teenagers within the confines of you know, their background and their behaviors. And at least 90 days before age 18, the court must ensure that the juvenile has access to their birth certificate, social security card, health insurance, driver's license, or other ID, educational and medical records. We all know that, you know, to be kind of a fully functioning adult, you know, you have to ID, you want to be able to have access to, you know, your records. If the youth is going to be pursuing college, they need to know how to get their educational records. And what you would hear sometimes from foster youth, former foster youth, is that it was almost like they were dumped on the street. You know, they left, it's kind of like, oh, you're 18, you're out of here. And they had no life skills to be able to get these documentation. And so this is a new requirement. It's state law, but it's, you know, required by the federal law so that we are allowing these youth to really transition from foster care into adulthood. So a permanent plan for older youth is a possible option, although it's usually kind of a permanency plan of last resort is how I like to look at it, but it's called another planned permanent living arrangement. And this is the first time in North Carolina statute that we have what's referred to as APLA spelled out. It's always been allowed as a permanency option under federal law, but because of these requirements and legislation, we now have B-912, that when APLA is a primary plan, for all, it can only be a primary permanent plan when the juvenile is 16 or 17. DSS has made diligent efforts to place the juvenile with a parent, relative, guardian, or adoptive family, and for some reason or another that's not been successful. That there are compelling reasons that adoption or guardianship are not in the best interest, and APLA is the best permanent plan. So it's really, you know, we're talking about these older youth that I think we all sort of recognize that they're going to age out of foster care. And for one reason or another, they may even vocally say, I don't want to be adopted, or I don't want to be, there to be a custody order. Or sometimes you have a situation where a foster parent says, I'm absolutely willing for this man to stay with me until he is 18, but you know, I don't want to be the official custodian or guardian. That can impact the foster board rate. And so that may be the kind of case where APLA is an appropriate permanent plan. So APLA can be what's called a concurrent plan for ages 14 to 18, but only the primary plan 16 and 17. Requires that the youth is placed in a family setting with a committed caretaker that is maintained at least 6 months. This is part of the kind of federal policy with respect to APLA. You're not going to find this in the state statute. But when we're talking about a committed caretaker, what we can't have, for instance, is a youth that's placed in a group home of APLA as a permanent plan because we don't have a specific committed caretaker. So that's what's distinctive about APLA being a permanent plan. So maybe somebody says, I'm not willing to be the guardian, but I am a committed caretaker. Now, under 7B912D, it requires that if APLA is approved as a permanent plan, the court shall question the youth and make findings of fact regarding the desired permanency outcome. So, the only time in statute in the juvenile code where it specifically instructs the court to question the juvenile. So we know sometimes juveniles do come to court. They may be called to testify as a witness, but this statute specifically requires the court to question the youth about APLA. So in situations where you've got a 16 or 17-year-old and APLA is going to be the permanent plan, you likely need to have the youth be put in court for questioning. And I think, we're their lives. It's good for advocacy reasons and for them to be involved in these decisions. Sometimes the youth is placed out of county, or maybe we have a youth that doesn't want to come to court. In that situation, it may be possible to, have a child sort of participate by telephone, but I think we're going to have to sort of see how that shakes out. My best advice is if we do have APLA as a permanent plan of a 16 or 17-year-old, we have that 16 and 17-year-old coming to court. I alluded to these driving barriers for foster youth. And the prior slides with respect to APLA, the reasonable and prudent parenting standard, these were some federal requirements of North Carolina. The bill sponsor, Senator Barringer, also recognized that foster youth have this situation where they don't have the ability to get a driver's license. And so the Foster Care Family Act allows for that situation. So it specifically permits a minor that's 16 or above that's in DSS custody to contract for automobile insurance. We know that you have to have liability insurance in North Carolina in order to drive. And so there's also a provision in law that doesn't allow minors to enter contracts. So this is a specific exception that allows a minor to get liability insurance. Now, the minor is responsible for the cost of premiums and assigned liability. So you're not every 16 and 17-year-old that you represent are going to have the financial ability, be enough and wherewithal to be able to get their driver's license. But hopefully there are some foster youth that are motivated, that do have part-time jobs, that will be able to pay for their liability insurance. Now, the other provision of this Foster Care Family Act addresses the driver's license application for a minor that's in DSS custody, and it provides that this application, and this is the application to get a North Carolina driver's license, signed by the applicant, which would be the foster youth. It can be the GAL, so a guardian ad litem can sign this application, or the attorney advocate, as long as you're appointed under 7B601, so you've got your appointment order. Can be the DSS director or designee. Designee would typically be the social worker, and then if no other person, then the court with jurisdiction over the minor's placement. So essentially, you could be signing the driver's license application for a foster youth that you represent who wants to get their driver's license. You will not take on any liability doing that. It's simply, typically the application is signed by a parent. The situation, it's permitted by statute that it can be the guardian ad litem or some assessed representative. I would encourage you, if in that situation, to talk with your GAL supervisor. This is not going to be every case that you're involved in, but if you do have a situation where you are representing a foster youth who's motivated and has the ability to get a driver's license, this may be something that you're going to be asked to do. Another area with respect to foster youth is extending basically jurisdiction or foster care beyond age 18. Initially, we had Senate Bill 424, which was the Fostering Success Act, and that was basically rolled into our appropriations bill. So the budget bill has a specific section that amends the foster care benefits program and allows the foster care benefits to be extended with DSS supervision to age 21 if the foster youth is pursuing secondary education, vocational education, employment program, or they're employed. Now, what's interesting about this is that the youth can opt out and then opt in before age 21. So sometimes you have an 18-year-old that says, you know what, I'm 18, I'm out of here. I do not want to be in foster care anymore. But then later they may realize, you know what, it was sure a lot easier when I was in foster care. So they can do that under the new legislation. They can opt back into foster care up to age 21. And, the other provision that this legislation allows for is that adoption assistance benefits will continue to age 21 if the youth was adopted after 16 or less than 18. So this is an incentive for youth to be adopted, because their foster parents are going to continue to get that adoption assistance to age 21. And creates a new statute in our juvenile code. It's 7910.1, review of voluntary foster care placements with young adults, and it requires that no more than 90 days that there's basically an agreement to extend foster care that's executed, and that you have to have a review hearing within 90 days of that execution. Now, this is not a hearing that guardian ad litem will be participating in, because remember, at this point, the minor is now an adult. So you will not be participating in these, but I felt like it was important for you to understand sort of that there will be some court oversight with respect to extending foster care. And it even defines a young adult in foster care in our general code, and that the parties to this review hearing are going to be the young adult in foster care and DSS. Now, what the legislation passed, like I said, as part of the budget bill in 2015, and requires that the Division of Social Services develop a plan to report to the General Assembly by March 1st, 2016, how they're going to execute this. But the effective date is January 1st of 2017. So while this legislation has been enacted, the provisions are not yet in place. So in the meantime, you may be aware of what are called CARS, which is a contractual agreement for residential services, and this is an agreement that a foster youth can enter with DSS to extend their foster care benefits. Okay, we are going to switch gears a little bit now, and I'm going to be talking about some specific changes to the Juvenile Code. And this is what's referred to as Session Law 2015-136, or House Bill 669, and there's two provisions that I think are most important probably for guardians ad litem. One deals really with a new concept of concurrent planning, although that's something we've always been doing. Now it will be statutory, required by the court, and there are also some changes with respect to CC reunification efforts. But before we get there, I'm going to cover a couple other provisions that are important. So the requirements of federal law is that states, parents who have siblings of a juvenile in care. So the idea being that, we can basically sibling placements together. So And North Carolina actually extended this. And not only do we have to notify a parent with a sibling, but we have to notify anybody with custody of a sibling. So what that's going to do is really, at the onset of the cases, looking at possible relative placements and recognizing the importance of sibling connections. So the amendments are actually found in our non-secure custody statutes and the pre-adjudication hearing, and it requires DSS to make diligent efforts to notify relatives and other persons with legal custody of a sibling of a juvenile that this juvenile is in care unless it's contrary to best interest. So there may be a situation where it's not in the child's best interest for this custodian to be aware, but in most situations, this is a possible placement provider. And remembering that we're doing this at the onset of the cases, so it's always better to identify relatives or other placements early in cases before a child gets funded into their foster placement. So it allows the court to consider persons with legal custody of a sibling as a placement option, and it's the same priority as what's termed non-relative kin. So we know that relatives have placement priority with respect to juveniles unless it's contrary to the juvenile's best interest. And then after relative priority, we now have basically this non-relative kin, which includes a person with custody of a sibling. That has changed is back to the medical consent authority of DSS. So the new statute is 7B 505.1, and what it does is it specifies DSS can consent to routine medical or dental care or treatment, or routine medical, surgical, psychiatric, psychological, or mental health care or treatment, testing and evaluation in exigent circumstances. So I'm not going to a lot of detail about the medical consent provisions since it's very much tuned to DSS, but give you some background. What would happen a lot of times is a child would come into non-secure custody and DSS sort of got this blanket authority to provide medical care for the juvenile. Well, the onset of the case where the parents' rights are still intact. And so there were some constitutional questions raised with respect to that. And so that's why now there's a statute in place to really give specifics about what medical consent DSS can provide. So the question is that parental consent or a hearing. So it specifies, the first slide dealt with sort of the routine or emergency medical treatment. But in other situations, then, DSS must obtain consent from the parent, guardian, or custodian, or if consent will not be given, then the court may authorize DSS to consent based on clear and convincing evidence that care, treatment, evaluation is in the child's best interest. So it's possible that you as a guardian ad litem would be involved in a hearing where DSS was asking the court to give them the authority to consent to specific care or treatment. And it may be because the parent is not unavailable to give consent, or it may be that they don't want to give consent. And bring that the court cannot order parents to give consent because consent must be voluntary. So just be aware of that, and if there is a hearing where there's a question about some medical treatment involving a child that you're appointed to represent, you certainly want to have information regarding the best interest of the child, have a position on whether the treatment is in fact in the best interest or not. It includes the statute specifies certain care and treatment, so psychotropic medications, clinical trials, immunizations, CME or CMHE, these are the child medical evaluations, medical, dental, if there's informed consent required, and then psychiatric, psychological, or mental health care that requires informed consent. Just a couple comments. Psychotropic medications, foster children, there's a higher incidence of the use of psychotropic medications, so we definitely want to monitor that. I think it's reasonable for the court to have information from medical providers regarding why a psychotropic medication is necessary for the treatment. And also just immunizations in North Carolina, only objection is a bona fide religious objection. And so you can't just object to an immunization based on, I just don't think it's a good idea. So we have a new statute at 7B 903.1 specific to juveniles that are placed in the custody of DSS. And what it allows for, it gives DSS specifically some decision-making authority that's generally made by a custodian. Now, this is something that DSS essentially has been doing. Wasn't a specific statute that really authorized this. So this is, in some ways, is just codifying practice. Statute also refers back to 7505.1, which is that medical consent statutory provision. Here we had talked about earlier the reasonable and prudent parenting standard, and so this is that idea that if a juvenile is placed in the custody of DSS, that the placement provider can make decisions about normal childhood activities. And provisions that were other areas of the juvenile code have now been placed in new 7B 93.1. One, just a reminder that DSS cannot do a trial placement or prevent unsupervised visits unless there's a hearing that specifies that it's in the child's best interest, and that if DSS intends to change a child's placement, they need to give guardian ad litem 72 hours notice unless there are exigent circumstances. The statutory provisions are exactly the same, but it was be found in 7B 905, and now it's under 7B 903.1 because it's specific to a juvenile placed in the custody of DSS. So now we're going to talk about reunification efforts and concurrent planning, which I alluded to at the beginning of this section. The statutory structure has now been amended where reunification efforts may not be required or may cease really kind of two junctures of the case. Either the initial disposition hearing, so early on in the case, we would cease reunification efforts, and then it's still permitted at permanency planning. However, there is a shift and a focus on concurrent planning, and we'll talk about that in more detail, but we're going to start with this idea of ceasing reunification efforts at disposition. We have 7B 901 C1 through 3, and what this allows is that the court can cease reunification efforts with a parent disposition based on certain aggravated circumstances. And those include sexual abuse, chronic physical or emotional abuse, and emotional abuse is a new aggravated circumstance. It used to only be physical. Toward abandonment, we have new chronic or toxic exposure to substances that causes the juvenile to be addicted, an act that increases the enormity or added injurious consequences. So these are these aggravated factors, and if the court makes written findings regarding these aggravated factors, then DSS does not have to provide reunification efforts. Findings to allow for cease is that there was a prior involuntary termination of parental rights. What we mean by that is that a court terminated parental rights. It was not a relinquishment. Or number 3, that the prior court determined that there was murder or manslaughter of another child of the parent, or attempted murder or manslaughter, assault causing bodily injury, sexual abuse, or there's the parent is on the sex offender registry. So if the court makes any of these findings, 1 through 3, those aggravated circumstances, the prior TPR, or these other determinations, then reunification efforts can cease at disposition. So the idea is instead of waiting until we're at that permanency planning stage and having reunification in every case, if we have an egregious case, of abuse or, kind of that repeat offender. In other words, we've seen this family before, we've got a severe history, then the court can seek a disposition. And so you need to be aware of that in your cases. If it's factually appropriate, that would be something we would be recommending. So, guys, we do still have the option of ceasing reunification efforts at the permanency planning stage. Now, remember, permanency planning hearings are required within 12 months of removal. The idea that at that point the court needs to be looking at what's the best permanent plan for the child. And what the new amendment specifies is if the court finds that reunification efforts would clearly be unsuccessful or be inconsistent with the juvenile's health or safety, then the court can cease reunification efforts. So the court has to make findings that would support why reunification efforts would be unsuccessful or inconsistent with the juvenile's health or safety. Now, previously we had a reference to the juvenile's need for a safe permanent home in a reasonable amount of time. That has been rescinded. It's no longer part of this specific statute, but this the need for permanence in a reasonable amount of time is still referenced in other areas of the juvenile code. So don't worry that this idea of timely permanence for children has not been, taken away from the code. So otherwise, reunification is going to continue as the primary or secondary plan. So that's why we had talked about, or I've alluded to, concurrent planning. Concurrent planning. So first, let's say, why ceasing? So, the idea is, why do we need to have this order ceasing reunification efforts? Remembering that what reunification efforts mean is that DSS is providing services to the parent for reunification. And when reunification efforts cease, it simply means that DSS doesn't have to provide those efforts. So it doesn't mean a parent can't be reunified. It's just that DSS is not going to be the one assisting the parent in basic case plan. So the no longer having to cease reunification efforts, it's not really necessary. And the federal reviewers came and looked at the Division of Social Services. They saw this in North Carolina as an area that needed improvement. The issue is also subject to appeal. So had several cases where the ceasing reunification order was overturned, and then ultimately that overturned a TPR. And so that has certainly been an issue. Children are more likely to lose touch with siblings. There's no accountability for parents at the TPR, so there's a period of time where the DSS is not working with the parent, and then we have the TPR, so you end up having sort of stale evidence. And reunification is delayed when the parents make progress. Maybe reunification efforts were ceased, but then they make some progress, and then we come back. And so these are some ideas behind the increment of concurrent planning. So we have a new statute at 7B 906.2, and it requires concurrent plans of a primary and secondary plan. And unless efforts have been ceased at disposition or have those findings that it would be futile and contrary to the juvenile's health and safety, reunification is going to be a concurrent plan. It may be the primary plan, or it could be a secondary plan. So that should also delineate the options for permanency: reunification, adoption, guardianship, custody, APLA, or statement of parental rights. So what about concurrent planning and having primary and secondary plans? Well, this slide is a great way to sort of look at it. So on the left-hand side, we have, this is where the parents are really on board. They're working their case plan. Reunification is the primary permanent plan with secondary plan of adoption. And this is a case that we think is going to be successful. And so most of the efforts that DSS is providing to the family are going towards reunification efforts. Only a very small percentage of the work of DSS going to the secondary plan of adoption. But on the right-hand side, this is where the family, the parents aren't really working their case plan. They're not doing very well. So adoption is 80%. That's the primary plan. So about 80% of the DSS workers' efforts are going towards implementing the permanent plan of adoption, with only 20% reunification. Now, it talks about percentages. Doesn't mean the court's going to say, oh, the primary plan is adoption for 80%. There's not going to be any kind of percentages that you have in court, but this is really just a visual for you to sort of understand how a DSS caseworker will be allotting his or her time in working with the family or working to finalize an alternative permanent plan. So, reasonable effort for permanent plans. The court shall identify the primary plan and the secondary plan. Remember, if reunifications haven't been ceased, then reunification must be under a primary or secondary plan. And it may even be possible to have a couple of secondary plans. The idea behind concurrent planning is, it's good to have plan B. We can't have a crystal ball to know exactly how the case is going to turn out. The idea of getting the juvenile court involved with the family is hopefully to effectuate reunification to get family well and the child placed back in the home. But if that's not possible, we need to provide for permanence. And so that's the idea behind having reunification be either the primary or secondary plan. And the court ordered DSS to make efforts to finalize both plans, specify efforts that are reasonable to achieve permanence. So that means that the court can even specify specifically what efforts are necessary to finalize one of the permanent plans. And then the court determines whether the prior efforts of DSS were reasonable to achieve permanency. So the first permanency planning hearing is going to be looking at reunification, and then subsequent hearings will address these concurrent plans. So in some ways, this isn't that much different. I always thought about, reunification is what we're working towards in the majority of cases out of the gate. So we're going to do that, but we're also going to have this Plan B to consider this concurrent plan. Area that is a little bit different is what I've termed parental accountability. And so what the legislators had really looked at is, there seems to be so much requirement of DSS to provide reasonable efforts. What about the parents being engaged in the process? And so we have 7B 906.2D that requires the court to make written findings about whether the parent's progress is adequate and within a reasonable amount of time, what parents' cooperation and participation with the plan, DS and the child's GAL, so they're looking at the relationship with the parent working with the agency and guardian ad litem, parent availability to come to court, to work with DSS and the child's GAL. So are the parents involved? Are you able to get in touch with them, especially if reunification is the plan? Whether or not the parent is acting in a manner consistent or inconsistent with the child's health and safety. The findings the court must consider at these permanency planning hearings. We have an amendment to the permanency planning statute where the judge must inform the parent, guardian, custodian of the consequences of failure to cooperate with the plan could result in an order seeking reunification effort. So this is sort of some legislative intent to make sure that parents have some accountability in the process. Finally, I wanted to just mention to you a couple bills of interest related to sex abuse. We have Session Law 2015-91, which allows for a no-contact order, with no expiration involving a sex offender. So when we have a crime victim of sex abuse, they can ask for a non-expiring permanent civil no-contact order. So just to be aware, if you do represent a child that is a victim of a sex offense and there's a criminal case, that this is something that can be pursued on their behalf to have a no-contact order. And the other bill that I thought would be of interest to you is Session Law 2015-183. And this is also related to this, the Trafficking Act, the federal legislation. And what the idea here is to really decriminalize prostitution when we're talking about minors, because, it's sex trafficking. It's not that, minors aren't prostituting, they're being prostituted. And so what it requires is that these juveniles be taken into protective custody as undisciplined, and then law enforcement must make a report of the alleged abuse or neglect to DSS. So that concludes the legislative update. I know I've covered a lot of information in a short amount of time, but I encourage you, if you have questions in your cases, to talk with GAL supervisor or your attorney advocate, and to know that we're all sort of this transition period with the new legislation, so it's going to take some time for everyone to get used to the new legislation, including judges. Thank you for listening.